ranking current, taking consideration 2021 CR. See, you're still trying to flirt with people. Mr. Villarreal.
What?
Nobody, Mr. Villarreal.
Yes,
People
ma'am.
are not trying to date you on this Zoom. All right, guy with the gold glasses. And lady, you're flirting with somebody who's an inmate. That means that you know you should not be flirting with people in the crowd. This is not a dating show.
None of my family here, I'm actually a lawyer. They cannot recite me. Just release me and let me go home. I have 3 kids and my kids went CBS.
I need you to listen to me clearly. Are you ready to listen?
I need a new attorney,
Are you ready to listen?
please.
Are you ready to listen? Attorney, this is your
It's been
attorney.
very rude and I'm not gonna accept it.
All right, here's the thing.
I'm just trying to work my case, man.
No, here's
Whose expense? Mine? Because if it's mine, I'm not sanctioned. Give me $100 fee. Woo
Okay,
woo.
well, so, pocketbook, I'm muting you for, all right, I'm gonna count that as, another.
all right, Mr. Reyes, are you able to understand me?
Yes, ma'am.
All right. So there's no language barrier between you and your attorney, is there?
Need another attorney, please.
All right, no, here's the thing.
Someone who's gonna. I didn't do anything wrong.
Well, no. Let me explain to you. And I want you to internalize what I'm saying, okay?
I just need a reset.
No. I want you to hear me out.
Time served.
Hear me out. Listen. Okay? I've been a defense attorney. I've been a prosecutor. In this court, listen. Be quiet and listen. Because if you don't listen, you're going to miss something. I require in this court that the state make an offer. Legally and ethically, once an offer has been made, your attorney must give you that offer. Whether or not you want to accept that offer or not is completely up to you. But your attorney has to present that offer to you. If you choose not to accept it, you can tell your attorney, no, I will not accept this offer, but ask the state to give me this. And then your attorney, which is called a counter offer. Then your attorney will go to the state and say, hey, my client said they'll accept this. And the state may say, well, we're not giving that. So your attorney cannot force the state to give you something that you want. So ultimately, if you decide not to accept the state's offer, if the state doesn't decide to dismiss this case, your only other option in this court is going to be that it's going for jury trial. So counsel, have you received all the discovery in each of these cases?
We have the discovery, Judge. The only thing we do not have is an offer because Marcus was in charge of the case.
Mhm.
We were here last week. He was going to contact the complainant with this. And I don't think that contact has been made. And so because he's a habitual, we really want to talk to the complainant witness and see if we can get this resolved.
Now, what I can tell you is the state hasn't proved that this is habitual or not, but based upon what you're charged with and based upon my education, if the state were to prove up the habitual, your minimum sentence is 25 years in the prison. So no. Here's the thing. I'm not getting into facts with you. I'm just telling you what I see. Now, I'm not accepting any of this as true because I haven't received any facts of the case. So, and I'm letting you know that because when you come to me and say, I want a judgment satisfied, I'm not allowed to know what your plea negotiation is. So when you ask for a judgment satisfied, I just want to let you know that if everything is proven, your minimum is 25 years. So you're talking judgment satisfied and minimum is 25 years. So there you go. We're going to come back on January 27th at 9 a.m.
Thank you, Judge. Maybe excuse.
Yes. All right. Hello. Are your clients in the center?
He has been evaluated, he's been found incompetent.
Okay.
So we have a hearing on the 20th, the agreed incompetence hearing before Judge Brothers.
All right, Ms. Ferguson, on Mr. Reyes, can you reset this for 60 days?
I need a new attorney.
All right, I understand. Thank you for letting me know. And we'll look into that. And my understanding is that you have a,
This is my first time being in jail for a burglary.
okay. All right, so here's the thing. All right. Everyone, could you please whisper? So, Mr. Reyes, I understand what you're saying, and I understand that you want a new attorney, but my understanding is that a doctor has seen you before I can even look into getting you a new attorney, because the doctor has made an evaluation. Your defense attorney is telling me that you have a hearing scheduled where that doctor will be present. When is that date, counsel?
On the 20th, Judge, next week.
All right. Oh, it's just the doctor who talked to you about any issues you may have, okay? You remember talking to a doctor? Okay, no, I understand. So what's going to end up happening is on April 20th, they're going to take you to a different court, and that'll be the court with Judge Carruthers. And then they'll have a hearing on what the doctor said his findings are, okay? And then after that, we'll address your issue with regards to a new attorney. But
No, I know my way home. I know my blood routes.
Mhm.
Last time I was here, the other judge told me I didn't need to take any medication or anything.
okay. All right. So if you feel that way, just be sure at at the hearing to let them know that, okay? So what will end up happening, Mr. Reyes, is your attorney is telling me that that hearing is set actually on April 20th.
That's correct, Judge.
And so they already have you in the system for April 20th, which is next week.
They also said I qualified for lifetime coverage.
Okay. All right. So what we'll do is we'll bring you back after that date on April 20th. I can't do anything with your case until they actually have a hearing on that. All right. All right. Thank you, Mr. Reyes.
Thank you, Judge. Maybe excuse.
Just one moment.
Just for the record, I spoke to him. He doesn't want me to represent him. There's also what he was found incompetent at once, and then he went to the process of restoration. The process of restoration, he did not participate in it. So they found him that he regained competency after that based
Do
on
you
other
think he's
reports.
confident?
I can say that. So I filed a motion for that earlier today. But
So you don't think he's confident?
I can't tell because he doesn't talk to me.
I have my reasons. I have medical reports. And I can take medication, but right now I choose not to because I want to work. You know what I'm saying? I'm trying to get probation. I've been incarcerated this whole time, trying to stay positive.
All right. So let me explain something to you.
I just need.
All right. This is what I need you to do. I need you to listen to me clearly. Are you ready to listen?
I need a new attorney,
Are you ready to listen?
please. That's all I'm
Are you ready to listen?
asking.
All right, so listen to me clearly. When you have a criminal case, if someone thinks that you're incompetent, which means you do not understand what the nature of your charges or the consequences of your charges, what ends up happening is they file a motion asking for a doctor to evaluate you. The reason why that is done is because he's not a medical doctor, I'm not a medical doctor. So a doctor will come and interview you. If a doctor determines that you are not competent, which means you don't understand the consequences of entering a plea or the consequences of your charges, they will either try to restore you and release you from custody, or they will send you to the state hospital. If the charge that you are facing is considered a violent offense, then they will send you to the state hospital. Your attorney cannot do anything until competency is restored. Once competency is restored, what that means is you go see Judge Andrew Carruthers, because he's the criminal law magistrate. They will have a hearing saying that your competency is restored. Then what will end up happening is you will be brought back to this court. And what I can tell you is you should be speaking to your attorney, because your attorney is telling me, here's the thing, your attorney,
I'm not gonna.
your attorney, here's the thing.
There's no
Wait,
witness.
here's the thing. Quiet. whether you want to sign for it or not, does not matter. And when I say it does not matter, it's because if you don't want to sign for it, then you'll get a jury trial. But if you don't speak to your attorney, he's saying that he thinks you may be incompetent. And you know what that means? Once an attorney tells a judge that they believe their client is
All
incompetent,
that.
the whole process starts over again. So that means that you will be sent back to have another hearing with another doctor. And then if that doctor thinks you are incompetent, you're going to go back to the state hospital and you're going to sit at the state hospital until they restore your competency. And then it's going to go back to Judge Carruthers. And then if Judge Carruthers says your competency is restored, then you'll come back to this court. And then if your attorney tells me, well, I think he's incompetent because he's not talking to me, then you know what will end up happening? You'll go right back. So talk to your attorney. If you don't want to accept what the state is offering, you don't have to.
You
Okay.
already knows that.
All
I
right, do
took
you
my
believe
test.
he's incompetent?
I'm not an expert judge,
confused
but
on this.
I have reason to believe that he has been diagnosed with mental illnesses in the past, and he is not on his medication for sure. So that's all I have from the reports I read. I just don't know, Judge.
All right, do you want to speak with your attorney so he can let the court know whether or not he thinks you should see another doctor? Or if you don't want to speak to him, I'm just going to go by what he says. When he says you need to speak to another
I
doctor.
already went on 24.
Do you wish to speak to your attorney?
No, I don't have an attorney.
All right, so you think he's incompetent?
Yes, Judge, I just.
All right, Norma, have him evaluated for competency.
Thank you, Judge. Maybe excuse.
Yes, thank you.
Now that's her.
Ah, here he is, Eric.
Excellent.
All right, yeah, you can go back to well, I'll move you to number 2. And Eric, I'll move you to number 2. Eric, click on it to go to breakout room number 2. All right, who's here on Eduardo Reyes?
Hey, Judge.
Come up here, up to the mic.
I was just asking for a new attorney, miss. I ain't been able to get that yet.
Oh, you can get a new attorney.
Please,
Yes, most definitely. You need to hire one.
yes. I don't need him representing.
No, you need to hire an attorney.
I know. I
All
don't
right,
need him.
so until you hire an attorney, this is your
It's been
attorney.
very rude and I'm not gonna accept it.
All right, here's the thing. You-
I'm just trying to work my case, man.
No,
I
here's,
went to SASH and I did my work.
okay,
I was there for 7 months doing my work to the best of my ability. I passed every test. I passed my evaluation
mhm.
and there's still no improvement or nothing or
Well,
anything.
let me explain something to you. I want you to listen to me, okay? So whenever you go to SASH
There's been a lot of
and you
mistakes.
pass, I know, here's the thing.
My
Listen, all
rights
right?
have been violated.
Will you listen? Are you gonna listen? Because if you're not gonna listen, I'm gonna have to send you back. All right. So when you go to SASH and they restore your competency, it takes a while. There actually has to be a hearing in front of Judge Carruthers to say that your competency has been restored. And then your attorney can work on your case. That's how it works.
I've been doing that,
So here's my question. Have you
studied all that.
studied?
Yes,
All right. And did you learn everything?
most of it, yes.
All right. Is there anything that you didn't learn?
I know that it's bothering me that I've been asking for a new attorney and that's what I need.
Mhm. All right, so this is your attorney. So
Not my
here's
attorney.
my question. Have you had a chance to review the evidence that the state has, that they say they have against you? Have you had a chance to see that?
There needs to be a lot of volunteer work. There needs to be a lot of that going on. Because there ain't nothing really, it's just been the same since I left. That's what it seems like. And I've learned. Best believe I learned and I'm trying to do right. I learned from that program.
Yeah.
The ups and downs, all that.
Mhm.
And I'm just asking for another chance, that's all.
Okay. No,
And I work for that. And that's all I'm asking. I want some probation at least.
all right. So let me, I want to tell you something about that. I understand that you're saying you did the work. And I appreciate your doing the work because it takes a
I
lot.
got all my homework here.
Oh, no, no, no.
My folder with my legal mail, I couldn't get that. I couldn't even bring that to show you that.
Oh, no, no, no. Here's the thing. You don't have to bring that to show me because I believe you. I believe you when you say you did the work. I believe you when you say that they said that you've been restored. Okay, so you don't have to show it to me because I believe that. So then the next step is this. Your counsel, have you had all of the discovery from the state?
I have the discovery judge, but he was just transferred from the hospital and the restoration hearing was about a week and a half.
Okay,
And so I have not had a chance to show him on Zoom what we have.
all right, so
The pandemic,
let me, wait a minute, let me stop.
COVID, all that.
Here's the thing, I want you to listen to me. All right. The state is here, your attorney is here. Do you want to see today the information the state has? Or do you want to set it for another?
10 years.
I'm not, here's the thing.
No 10 years
No,
time. TDC,
No, this is
I'm
what
not
you,
gonna
no,
support that.
this is what, so I know what's going on now. What's going on now is he does not like the offer that has been extended to him. So what we'll do is we'll set this for jury trial and a plea deadline date. Ms. Ferguson, state, how long do you expect this trial to last?
Judges, it should. With jury selection, probably possibly 3 days, Your Honor.
All right, could I have a jury trial date for him and plea deadline date? It'll be the same. And Deputy Laura, when he's brought back, he'll need to be brought dressed for trial. All right, so we're gonna bring you over December 9th for jury trial. All right, thank you.
New attorney, with the new attorney,
This will be your attorney unless you hire one.
I don't need him. I don't want him as my attorney.
All right, thank you very much for informing me of that. All right,
Maybe excuse you.
yes.
Thank you.
Oh, could you make sure that you do an acknowledgement of discovery?
Yes.
All right, thank you.
He's been seen. He was found incompetent first,
Okay.
and then he was at the hospital, refused to take medications.
Ah,
When the order to force medication came in or was threatened, he just behaved normal.
okay.
And the reports itself speaks loud about that he kind of, they suggest that he's malingering. I've been trying to talk to him. He comes to Zoom, he sees me, and he just turns back around. If we want to have him seen again, we can do that.
Do you think he needs to be seen again?
I mean, I'm not an expert on that. I mean, I've seen people that clearly show signs of incompetency.
Mhm.
He knows who we are. He knows things, but I mean,
So
for
do
all
you,
safe and everybody's, out of caution, that would be a good idea.
all right, Ms. Ferguson? Refer him for another competency evaluation?
Yes, ma'am.
In the magistrate court. All right.
Hello.
Hello, am I pronouncing your last name correctly, Jahir?
Yes, yeah, you're right.
All right, thank you. So what's going to end up happening is they're going to have some doctors speak to you again. So we're going to reset your case. Ms. Ferguson, if you can reset this for,
Why do they reset? I've been here for 7 months and I have 3 kids to take care of myself. I'm a mother and a father. And I have never done anything. They just gave me inside my garage and three men ran over me. And you see the way I lose weight, I haven't eaten no food and I'm dying here. None of my family here. I'm actually a lawyer. They cannot recite me. Just release me and let me go home. I have 3 kids and my kids went CBS. And I don't have nobody help me. I don't have nobody be there because they took my phone. And I have 7 lawyers. 7 lawyers represent me. They're not here. My family is not here. My kids is CBS. I never done anything. I was in my garage, 3 men ran on me. By the way, I have the video. They never record me. And I'm not supposed to be here.
okay,
So I need to go home, please. That's what I requested.
all right, thank you for letting me know that. All right, Ms. Ferguson,
That's what I requested. Because
Okay.
my kids almost like 7 months, CBS, and I have to go jail, another jail. This is wrongful. I'm not supposed to be here.
all right, so this is what we'll do. We'll have your civil lawyer, we'll make sure that the civil lawyer is here as well for our next setting. Ms. Ferguson, Deputy Laura, she can go back.
She made me famous for about 20 minutes or so. Apparently I came out on TikTok doing a plea.
Okay.
And my niece and nephews and my sons and were all calling me and I said, Dad, you're famous, you're famous.
Oh,
You're on TikTok.
well, and you know what's so funny? Somebody asked me one time, they said, are you on LinkedIn? I said, I think I was on LinkedIn from 1997 or something.
Yeah.
So I do not know much about the technology. I'm trying to work on being more. You were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could, off the record for a moment, excuse me, the lady in the black top with the red or burgundy spots on it, are you on the docket today? Are you here for someone else? I'm sorry? All right, so you need to move because you're flirting with the inmate. That's not allowed. So you need to step outside. Deputy, remove her. And who were you here for? All right, guy with the gold glasses. And lady, you're flirting with somebody who's an inmate. That means that he's not doing anything for you. And you're down here where you should probably be at work. And if you have children, you should be concentrating on your children. You're not allowed back in the courtroom. You're excused. You know you should not be flirting with people in the crowd. This is not a dating show. And while we're off the record, Mr. Gonzalez, I noticed a mark on your arm. You need to make sure you have a doctor look at that, okay? Don't wait till the last minute.
But just, that was his wife, and I.
Yeah, that's no flirting.
I understand.
Yeah.
I just want.
Yeah. Still not able to flirt. No flirting in the courtroom. Yeah. All right, we're back on the record.
Okay, what can I do to help you all today?
Yes, sir. Get us off of your docket is what you could do. Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball,
Yes,
Yes,
sir. Specific.
go ahead, Ms. Kimball.
a custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah,
And
blah.
stop talking. You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me. Or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions. And then we ultimately never got a response, and she filed a motion for
She
protection.
got plenty of responses. Objection.
What's your objection? Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She
to
also represents Cody and all fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So Ms. Kimball, why don't you just go ahead and finish telling me what, so you said that you're wanting A drug screen, so drug test, and do you say psychological or psychiatric? I thought you said
A psychological exam. And then we have a order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition and for attorney's fees for $1,500.
Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front, I'll fell for marijuana.
When was the last
But
time?
I'm happy to take it
Hold on.
on
When was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight. So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense,
Stop.
but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can
Kimball.
just, if you're gonna use
Respect-
my last name, that's
Okay.
fine. Just say Judge Tanike. Okay, it's pretty easy.
Okay.
So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tanike.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your
That's
position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I would propose.
And whose expense? Mine? Because if it's mine, I'm not sanctioned. Give me $100 fee. Woo
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're gonna want,
Stop. That's not something that she asked for. Ms. Kimball, what dates?
no,
What
been
date are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting, how long? That's a valid question. Is it half day, an hour, 2 hours? What do you
I
anticipate?
would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Yep.
Yep.
Supposed to start at 9 a.m.
What date?
So that question is to you. Never
I
mind.
said what
I'm not
time?
gonna let you
Time,
pick.
date, you know, these
I'm not gonna
things.
let you look. You don't get to do this for your own pocketbook. I'm muting you for, all right, I'm gonna count that as another violation. So in terms of the request for the deposition,
2-8, State of Texas versus Christopher Villarreal. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
James Tochi, judge for Mr. Villarreal.
And are you Mr. Villarreal?
Yes, ma'am.
All right, Mr. Villarreal, stop flirting with people.
How you doing today, Your Honor?
I'm doing great. You know, celebrate Valentine's Day with somebody who's not on the Zoom screen, okay?
Yes, ma'am.
Everybody here is married. Let's not start any problems.
No, I already caused enough problems. I learned my lesson.
Okay, I'm gonna show you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, or did you review it with your client?
Yes,
Yes,
ma'am, I
ma'am.
did.
Court will find that the state is in compliance with discovery. Mr. Villarreal, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Villarreal, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, peace officer, or judge, bodily injury? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Villarreal, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $1,000 fine. There are no applications. The state will take in consideration 2021 CR 10286 and County Court Cause number 677100. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is.
State, is that the plea bargain agreement?
Yes, it is.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Next, I'm showing you outside the plea bargain agreement. The state is requesting a no contact order with Eustacio, EUSTACIO, Tiarina, TIJERINA, as a condition of parole. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
If the offense is charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No content.
State, any evidence to support the defendant's no contest plea?
Yes, Judge. The state offers States Exhibit 1 and all attachments.
Any objections?
No, ma'am.
Mr. Villarreal, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Judge, we are prepared, yes.
All right, anything you wish to say on behalf of your client?
No, ma'am, just that you honor the plea agreement.
All right, it appeared that your client wanted to say something to the court. Does he want to say something to the court or no?
I don't know.
Yes, ma'am.
I guess the question is, Mr. Toshi, do you want Mr. Villarreal to say something to the court? It's
Honestly, no. I'm not sure what he's going to say at this point.
okay.
Other than expressing his gratitude, I hope. But is that it, Christopher?
I mean, yeah and no. You know, like I was, you know what? Yeah, that'll be it. That'll be it.
All right. All right. The court is going to follow your agreement, sentence you to 2 years in prison, $1,000 fine, time and money to run concurrent, taking consideration 2021 CR. See, you're still trying to flirt with people, Mr. Villarreal.
What?
Nobody, Mr. Villarreal.
Yes,
People
ma'am.
are not trying to date you on this Zoom.
I don't want that.
Okay,
I'm
2000.
believing it.
All right, just a second. Court is taking in consideration 2021 CR 10286, County Court cause number 677100. There's been no contact with Eustacio D. Tiarino as a condition of parole. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you want to know what a weapon is or ammunition, you'll need to contact an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. Good luck to you, Mr. Villarreal.
Thank you, ma'am, and enjoy your Valentine's.
All right, thank you. I'm going to do my best, but don't be Grandpa Villarreal at the prison.
I'm only 29, ma'am.
Yeah, but time sneaks up on you.
Don't it?
Yeah, Father Time, you can't trust him. All right.
Uncle Villarreal.
Yes.
That sounds better. That sounds better.
All right, I know some uncles who are in their 90s. Yeah, okay. Norma, Mr. Villarreal can go back. He's
Judge, you've given me a great idea. How did we miss this one? Like Zoom date, Zoom flirt.
okay. But is your wife going to be happy with the Zoom date? I think not.
Well, she'd be happy if I founded it and made $700 million. Yes. I'm not saying to get on it, but I mean, this is.
Well, I would tell you, I've had attorneys, just so people will know, purposely setting cases in this court on Valentine's Day because they are not prepared. I'll take the heat for it.
I hadn't even thought of that. That's a good one.
All right, I'm going to stop live stream. Everyone.
Running down to Atascosa County because parole wouldn't call me back to tell me whether it was Zoom or live. And so I ran down to Jordanton and then did Zooms there and then found out it was on Zoom and then drove to Poteet and waited and did a couple of hearings there.
Oh,
and
did you
then
pick up some strawberries while you're in Poteet?
they're not in season, Judge.
Well,
I mean,
what
it's
is
coming to the
HEB
end.
doing? They have strawberries at the grocery store and they look
we're-
nice.
We're almost there. Those are like, they come from like Chile or something, Judge. It's
I always say drives are nice and take advantage of the drives. Maybe, we used to always drive to Ruston, Brenna. Ruston peaches. Oh my gosh, they were so mouth-watering. And everyone would sell them on the side of the road and you would stop and get some. But here we are.
I've managed to do 4 pleas and get a dismissal and a couple of other appearances and that trip to Poteet. I think I had like 7 minutes for lunch. So it's been one of those days, Judge.
Okay, well,
So.
Brenna had inmates flirting with her, so.
I'm sure that is not an isolated incident, Judge, either with her or you. So.
All right. Thank you. Have a great rest of your day. Now
Thank you,
Brenna is
Judge.
blushing. Okay.